Deadlines ticking away. We've got the District of Columbia and Judge Boasberg, who we've covered a lot here, very problematic judge, who said Trump doesn't even have the authority to deport terrorists from Tren de Aragua, said pick up that airplane and bring it on back here. Judge wants them in America, probably wouldn't want them in his household, but maybe that's where they should go. But anyways, this judge said to Trump, we covered this yesterday, you need to give me the details of these terrorists that you deported out of our country. When did the airplane pick up? When did it land? Who was on it? How many people? Who gave the orders to say take off? I gave you an order to say turn the plane around. When did that order get received? So on and so forth. Give me the details, because the judge is not happy, right? The judge, I want those terrorists back here in America. So what happened is, after the judge ordered that to be provided to him, Trump and the departments appealed this up to the Court of Appeals in the District of Columbia, and then also submitted a request to stay the prior order, right? So give us some more time. Here is what they wrote from the DOJ to Judge Boasberg, who should be impeached. They say, all right, listen, Judge, what began as a dispute between litigants over the president's authority to protect national security and manage foreign relations pursuant to long-standing congressional authorization and the Constitution, which includes the president's core constitutional authorities. It started as that, but now, Judge, this has devolved into a picayune dispute over the micromanagement of immaterial fact-finding. So now you want flight logs and more. Explaining, in a series of orders, this court has requested the government to provide details about the movements of aircraft outside the United States and interactions with foreign nations, which have no bearing on any legal issue at stake in this case at all. And remember, the people who were suing these JGGs, right, they're all proceeding under pseudonyms, and there's several of them who are still in the country. This judge from DC issued order covering the entire nation, saying Trump can't deport any of these people, not only the people who are just a party to this lawsuit. Maybe say, okay, they're suing, so don't put them on an airplane, because they're literally suing. But everyone else, go. Unless you want to file a lawsuit too. You can file a lawsuit from Guatemala. That's fine, but not here. Now, the underlying premise of these orders, writes Trump, including the most recent one requiring the production of these facts ex parte today at noon, is that the judicial branch is superior to the executive branch, right? The judge is in charge of the country, not Trump, particularly on non-legal matters involving foreign affairs and national security. Now, the government, Trump, disagrees. The two branches are co-equal, okay? So you can give us an order, but if the Constitution provides us the power to do what we're doing, your order doesn't override our co-equal power. They're co-equal. You're not in charge of us. And the court's continued intrusions into the prerogatives of the executive branch, especially on a non-legal, factually irrelevant matter, should end. Now, the court's pending questions relate to a comment by the court to a government attorney, suggesting, incorrectly by the way, that the attorney had the ability to divert aircraft operating at the president's direction on an extraterritorial mission to remove members of a designated terrorist foreign organization from the United States in connection with one or more sensitive diplomatic agreements requiring months of negotiation. In other words, Judge, you're insane. You want some attorney who's in your courtroom representing one case out of thousands? Do you think he's like Jack Bauer or something? He just picks up the phone, turn it around. Beep, beep. No, he doesn't have that authority. And they put that in that very big, intentionally run-on sentence to make that point and hammer it home. The comment betrayed a complete misunderstanding of the serious national security, safety, regulatory, and logistical problems presented by a fee from the court directed at pilots operating outside the United States, and was made without regard to whether any such aircraft could even feasibly be diverted or even had enough fuel to safely do so. The judge is in charge. He just gets to control everything now. No, turn it around. There's no fuel around. Are you violating a direct order? No, Your Honor, there's literally no fuel in the plane. Bring it home. All right, okay, here we go. Now, further, the court did not pause the hearing to even give the attorneys an opportunity to act on the remark, and it did not memorialize the remark in a subsequent minute order. Okay, the judge didn't write, turn the plane around immediately when he issued the order, because remember, there was a hearing, and in the hearing, the judge made a big ranty lecture and was screaming about, do this, and I want to know, and then actually memorialized it, wrote it down in the order, and the order didn't say all that stuff. So they said, we're going off of the order. And the order came out after planes were already in the air. Now, there is no serious dispute, writes Trump, that the government complied with the minute order that came down. And the pending questions that you're demanding of the DOJ are grave encroachments on core aspects of absolute and unreviewable. You cannot judge what the president is doing on these things. Do you understand why that is, Judge? Because that makes you the president. There are certain decisions that have to be made that are the president's. They don't get to be reviewed because they're the president's decisions. If they're reviewed by a judge, then the judge is the president, and the judge is not politically accountable. They're appointed for life. And we don't want that to happen in our country, lest we have a dictatorship where judges are in control of everything and they're not accountable to the people unless you impeach them, which has set a very high standard, right? So this judge, and these judges, by the way, who are in the sake of protecting American democracy or whatever justification they're giving for crapping all over the Constitution, they're the ones who are acting like tyrants and dictators by seizing power from a co-equal branch of government as their own. Trump continues, executive branch authority relating to national security, foreign relations, and foreign policy are unreviewable. Even addressing the questions in an ex parte submission, in other words, they're just going to send it to the judge, not to the other side, would result in an immediate flood of media inquiries and demand for more information. It would subject the diplomatic relationships to unacceptable uncertainty about how the court will address those demands. And worse, the risks that are created by addressing the court's questions would also undermine the executive branch's ability to negotiate with foreign sovereigns and to engage in those negotiations, and poses a serious risk of micromanaged and unnecessary judicial fishing expeditions and potential public disclosure, right? They're not going to like that. I mean, the judge generally doesn't like that because this is saying, hey, judge, you're illegitimate in asking these questions. This is a fishing expedition. Okay, this is the type of language that prosecutors would always send to me and my firm when we would send out our discovery filings. You don't need that. What are you going to do with that? Oh, well, we're going to show your cop's a liar. You don't need that, Your Honor. They're just on a fishing expedition. And I hated it. Like, you sons of bees, I know you just copy and paste that in every one of these things. But now they're sending it to the judge. Now the judge can be like, going to have that same reaction I did. What? Judge, these are perfectly legitimate. Now, accordingly, defendants seek a stay of this order today, requiring the production of specific information ex parte tomorrow under 24 hours at noon today. Now, the government continues to object to this compelled disclosure. This material is information is immaterial, and what the court is doing is representing grave usurpations of the president's powers under the Alien Enemies Act and under Article 2 powers. Now, subject to our continuing objection, the stay is warranted here for 4 reasons. We need more time on this. First, the states are having to currently evaluate, the defendants are having to currently evaluate whether state secrets privilege applies. This court is seeking information. They're saying, no, you can't have it. So they're determining whether and how to invoke that privilege. There are weighty considerations there, specific procedures that they have to follow. The court wants a 21-hour turnaround time. We can't do it in time. So this court itself raised the possibility that state secrets might apply. So we're bringing it to your attention. So the government cannot hastily conduct an evaluation of the invocation of that privilege, except in exigent circumstances. And the flight path of an airplane that landed 3 days ago is not an exigent circumstance to invoke state secrets. So we can't do that so quickly now. So we have to figure out if there's another way to do that. So this court, because we have to do that, should therefore stay or delay its order, requiring us to give you this info so we can have an opportunity to make an orderly but expedited decision about whether we are invoking state secret and whether and to what extent. Indeed, the Supreme Court has instructed that a formula of compromise must be applied to cases in which the state secrets privilege may be raised and more. Now, a cautious approach, so we have more time on this, rather than an expedited deadline of less than 24 hours, is warranted to avoid forcing the government into a Hobson's choice, which is a hasty and potentially under-examination and invocation of the state secret privilege or the release of national security information. So it's either the judge saying you got 24 hours, one or the other. State secrets or give it to me. It's very sensitive information. So can we have more than that, Judge? To that end, the formula of compromise in this case is simple. Delay the court's order until the Court of Appeals has ruled on a further stay. Now, second, A stay is also warranted because a decision by the D.C. Circuit Court of Appeals on the government's stay is likely imminent. That court set a highly expedited briefing schedule, which should be completed by today, a decision that will likely be issued by the end of the week. Of course, we'll cover it. Now, that decision is expected to provide important guidance as to this court's authority to review presidential decisions under the Alien Enemies Act, right? Can they even judge anything that Trump does under it? Now, as the government has explained in its prior motion, this case is not even justiciable, okay? They cannot sue us on this issue. You can't sue the president over something that he is allowed to do. In particular, the D.C. Circuit, you guys have explicitly characterized the Alien Enemies Act as providing, you said it in your case law back in 1946, you wrote, it is unreviewable power in the president to restrain and to provide for the removal of and aliens of enemies in time of war, which is the essence of the act, right? So maybe they're going to say, well, it's not the time of war. Trump says it is. It certainly feels like it. Saying this is binding authority, all right? It's you guys wrote, it's unreviewable. That is binding on you, Judge. It underscores why judicial intervention is particularly unwarranted here. The government also possesses very strong arguments that their claims suing Trump necessarily and exclusively sound in habeas, which would incontrovertibly preclude this court's assertion of jurisdiction. So about detention of this person, which would bring it under the Alien Enemies Act, which would say you cannot review that court, right? So particularly because this court's inquiries relate only to retrospective and immaterial facts. In other words, you're asking questions about stuff that is old. It's done. And it's immaterial to the people who are a party to this lawsuit. The people who are suing here are still in the country. And it's not even about future compliance, okay? There is simply no need for the information that you're trying to get. And moreover, writes Trump in the DOJ, the government has already set forth its arguments for why its actions complied with the minute order from before. It does not require reference to any information that you seek. And the people suing have not explained why they need any of this information. In short, both you and the people suing are seeking information about a past event the government has already spoken. It has no salience to the plaintiff's claims here. Continuing to beat a dead horse solely for the sake of prying from the government legally immaterial facts and wholly within a sphere of core functions of the executive branch is both purposeless and frustrating to the consideration of the actual legal issues at stake in this case. This consideration also warrants a stay. And third, disclosure of the information sought could implicate the affairs of the United States and allies and their cooperation with the U.S. government in fighting terrorists. Such disclosure would unquestionably create serious repercussions for the executive branch and the conducting of foreign affairs. The prospect of hasty and wholly unnecessary disclosure of this information, which these continued proceedings have made manifest, would have a chilling effect on the willingness of other nations to cooperate with us. The court has no basis to intrude on the conduct of foreign affairs by the government, and a more deliberative and respectful approach is warranted, Judge Boasberg. And fourth, the government does not currently have any assurance at this time that information provided to this court on an ex parte basis, just separately to the court, not giving it to the plaintiffs, would not subsequently be provided to the plaintiffs or the general public before the government could seek appellate review of that further disclosure. In other words, you're going to leak it, Judge. And once that secondary disclosure occurred, any opportunity for appellate review would then be moot, and the damage would be done, and the effect on U.S. foreign policy would be catastrophic. And so therefore, the court should do something. And the government requests that the court mandates disclosure of information that was sought, that the court commit to not make any further disclosures of information so that the courts of appeals could review this. Now, in conclusion, Trump's DOJ submits, the court has now spent more time trying to ferret out information about the government's flight schedules and relations with foreign countries than it did investigating the facts before certifying the class action in this case. And remember, all these illegal terrorists, Tren de Aragua, formed a class action. The judge said, oh, you're being oppressed. And the class is what made it so that all of the other people all across the country are now in a class action lawsuit against our government from being deported. And this judge from Washington, D.C., Judge Boasberg, is like, yeah, no, it's great. Yeah. Like a products liability claim because of Trump. Now, that observation reflects how upside down this case has become, as digressive micromanagement from you has outweighed consideration of the case's legal issues. The distraction of the specific facts surrounding the movements of an airplane has derailed this case long enough and should end until the circuit court has had a chance to weigh in on any of this. The government respects that you, Judge, that this court respects this court and has complied with its request to present the government's position on the legality of the TRO soon. But the government now asks this court to accord it, the government, the same respect as a co-equal branch by staying its order until the important issues raised by this case are considered by the circuit court, the Court of Appeals. Trump requests a stay of this court's March 18th order, signed here by Drew C. Ensign, Deputy AG, Assistant AG, out there in Washington, D.C. So a nice filing that came in. They had a deadline that was ticking today. The judge came out with an order, and the judge responded to this with a little bit of an attitude. Here's what the judge said. Mere hours before their filing deadline, when they were supposed to give us this stuff, the judge says, and characterizing the court's proceedings as a picayune dispute, which is trivial or minor. It's like airplanes. Picayune judge. Over the micromanagement of immaterial fact-finding, that judge didn't like that one either. Now Trump seeks to stay the court's order, requiring them to produce in camera particular information. So that's just specifically to the judge. They were saying ex parte, we're just going to provide it to the judge separately. The judge is saying, I'm going to look at it in my chambers. Now, although their grounds for such request at first blush are not persuasive, writes this judge, the court will extend the deadline for one more day. Thanks, Judge. Now, to begin, this court seeks this information not as a micromanaged and unnecessary judicial fishing expedition. See, I knew that was coming. But to determine if the government deliberately flouted its orders. I'm investigating you. And if so, what the consequences should be. Sanctions, contempt, then they'll blame Trump for it, and then they'll say impeachment, right? So follow the bouncing ball till we get to impeachment. They're trying to set him up. They've been doing it for months now. Now, the government requests a stay or delay, in part to make an orderly but expedited decision about state secrets. Now, the judge writes, that privilege exists, state secrets, when there is reasonable danger that compulsion of the evidence would expose military matters, which in the interest of national security should not be divulged. And so when those circumstances exist, courts do not jeopardize the security which the privilege is meant to protect by insisting on an examination of the evidence, even by the judge alone in chambers. The privilege is not to be lightly invoked, right? So don't just say, oh, everything's a state secret. To do so, the government must make a formal claim of privilege lodged by the head of the department, which has control over the matter after actual personal consideration of that officer. That's according to case law. Now, the government's motion is the first time, says the judge, it has even suggested that disclosing the information could amount to the release of state secrets. To date, in fact, the government has made no claim that the information at issue is even classified. Classification is generally less protective than state secrets, so it seems like it's uncommon for the disclosure of unclassified information to threaten state secrets, says the judge, right? He's calling their bluff. Oh, state secrets. First time I've heard of it, and so it seems pretty weird. It's not even class. So defendants, Trump, relatedly maintain the quote, even addressing the questions in an ex parte submission, like separate from the other side, they say it's going to create a flood of inquiry about this. But they say, you're upset that the media is going to ask for information? You're promoting your own flights. Even Marco Rubio revealed some of the operational details of the flights, including the number of people on the flights, many of their identities, the facilities where they were brought, their manner of treatment, the time window in which these events occurred, and more. Even Rubio posting this on X at 8:39. The court is therefore unsure at this time how compliance with its minute order would jeopardize state secrets. Are you going to invoke it or not? But the court will nonetheless grant the government an additional 24 hours for you, Trump, to consider whether to invoke the state secrets privilege. If it does invoke it, this court is obligated to determine whether the circumstances are appropriate for the claim of that privilege, and the judge can inquire and get and request more information, right? So if they invoke it, then it's opening a whole new box. Now, as our circuit has cautioned, the privilege may not be used to shield material not strictly necessary to prevent injury to national security. And so don't say it's secret if it's not. Now, while the court will permit this additional time, it's not persuaded by Trump's contention that a stay is warranted here. The government reiterates its arguments that that TROs were lawfully defective, but has already explained The court seeks factual information to determine compliance with the TROs, not to determine whether I was wrong in granting the TRO. It's whether you complied with the TRO. Now, the government doesn't explain how in-camera review and disclosure to the court, like how the court, if the judge gets it, how that could be damaging to the United States. The judge is like, well, I'm secretive. I'm not going to give it out. So last, the government claims that it needs assurances by the court that the court would not disclose anything. The court says, the court has no problem offering that assurance. Okay, we're not going to leak any of that stuff. So stop complaining about it. So the court, through James E. Boasberg, aka Jeb, says the motion is granted in part and denied in part. So deadline has now expired, but got extended. Says they shall have until March 20th at noon to provide the information or to invoke the state secret doctrine and explain the basis for such invocation. So coming in hot tomorrow. We're either waiting for a decision from the Court of Appeals out of the District of Columbia staying this requirement. Trump will come back tomorrow, submit an invocation of the state secrets filing, or will provide answers to the questions tomorrow. I think if anything, it's probably going to be the latter. And the answers will be the bare minimum just to get a passing grade, to be in compliance with the court's order. But we'll see. Maybe the Court of Appeals will step in and do something tomorrow.